related to the Affordable Care Act that is before the Supreme Court. And to understand the current lawsuit, you have to go back in time a little to understand how we are where we are today. So you first need to go back to that little kind of lime-colored bubble back in 2012, when the Supreme Court in an earlier case found that the individual mandate, the requirement that you have health insurance, and if not, you pay a penalty with your taxes, that is legal as long as it's a tax. There was a discussion, the legal question was whether Congress can pass a law requiring you to buy something. They decided, well, they can't make you buy something, but they can implement a tax penalty if you don't. So that's what the Supreme Court found back in 2012. In 2017, Congress passed comprehensive tax reform legislation in December of that year that made lots of changes to our tax code. But one of the changes is that they basically zeroed out the individual mandate penalty. So the law still says you have to have health insurance, and if you don't, you pay a penalty. But where it used to say, you pay a penalty of $500, now it says you pay a penalty of $0. So the penalty is still there, but not really, because there's no dollar figure associated with that. So that was in 2017, and then in 2018, 20 state attorneys general filed lawsuits basically saying, well, if the individual mandate penalty has gone, that basically means the individual mandate has gone. The individual mandate is gone. Every other part of the ACA is inextricably linked with the mandate, and so then the entire law should be thrown out, and that's what they have been pushing for. Next slide, please. So in the first step, the case was filed in Texas, and in December 2018, the first judge basically agreed with the Texas and the other states. Yes, the mandate's gone. Yes, that means it's unconstitutional, or the penalty's gone. Mandate's unconstitutional. Entirety of ACA is unconstitutional as well. But he issued a stay so that the law stands during appeals. It then was appealed to the Fifth Circuit Court of Appeals. The next December, the court ruled that the individual mandate is unconstitutional because it's no longer producing revenue. But rather than dealing with the question of, okay, well, if the mandate's unconstitutional, what of the rest of the law would have to go to? They basically sent it back to the first judge to say, you need to reconsider which parts of the law have to go. As a fun aside, I was actually on a plane about to take off to go to India for 2 weeks of vacation over Christmas break when the decision came out. And so I read it on my phone and emailed everybody like as we were taxiing, and I thought I was going to get in trouble. Luckily I didn't, but I will always remember that day. It was very dramatic. So flash forward, rather than going back to the judge in step one, now a bunch of Democratic attorneys general decided, no, we should appeal to the Supreme Court. Like, we don't want to go back to the Texas judge and then back to the Fifth Circuit. We're going to go straight to the Supreme Court and have this question resolved once and for all. And the case is now being led by the California Attorney General, and it's now called California v. Texas. An oral argument was held last week. Next slide, please. Oh, I just found this actually, and I thought it was really cool. Like, if you ever wanted just a really clear understanding of how partisan the Affordable Care Act is, like this map shows. So basically, all the orange states are the ones on the side of the lawsuit that says the entire ACA should be thrown out. And everybody in the dark blue is on the part of the lawsuit saying, no, the entire ACA should stand. And then the states in kind of blues and greens have been supportive of the ACA in other ways. So there's only 4 states, Idaho, Wyoming, Alaska, and Oklahoma, who have not formally taken a position one way or the other on this lawsuit, which I think also goes to show how important how important it is. I think this also, frankly, shows that, you know, if part of the ACA were found to be unconstitutional and states could go back to setting rules rather than the federal government, whether you as a person with a bleeding disorder had access to insurance that covered what you needed would again be determined by where you live. And that was, I think, kind of the point of the ACA, is that no matter where you live, if you have hemophilia, you should be able to access insurance. Next slide, please. So what's going to happen with all of that background? So the main legal questions relate to standing and severability. So standing is, should there be a case in the first place? Have the original people in Texas who filed the lawsuit been harmed? They say they have, that even though there's no penalty, just having the individual mandate on the books is compelling them to buy health insurance, which they don't want to do. The other thing is, do any of the states, you know, I just showed that there's 46 states involved one way or the other. Do any of them have standing in the lawsuit? And so the first thing that could happen is that the Supreme Court could dismiss the case based on standing. They could say, no, nobody's really been harmed, and we don't think this case has merit. I think that's very unlikely. There were questions related to that during the oral argument, but they could have declined to take the case in the first place if they didn't think there was standing. So I think I would be really surprised if that was how the case was resolved. The bigger question has to do with severability, which is like the legal term for how much of the entire ACA is so closely tied to the individual mandate that if the mandate is unconstitutional, you know, these other provisions have to go too. And let's remember, like, the ACA was a 2,000-page law that did tons of stuff that had nothing to do with private insurance coverage, which is kind of what you think the mandate is most closely tied to. There are rules about labeling menus for calories. There is a pathway, it created a pathway at the FDA for biosimilars, like generic versions of biologics, to be approved. There's the Medicaid expansion, of course. There's the creation of a new program to test different policy ideas in Medicare. You know, there's countless things that were included in the law. You know, and the question is, well, so say the mandate is gone or should be found unconstitutional, does like menu labeling really have anything to do with that? You know, and that's maybe an easy thing because you think, well, not really, right? But there are provisions that are much more closely tied that we care a lot about, like the pre-existing condition protections, ban on lifetime and annual caps, et cetera. So it's always difficult. You know, Lynn and I were joking about my crystal ball. You never want to judge what's going to happen with a Supreme Court case based on oral argument, because justices often ask questions as kind of devil's advocate. And so sometimes they're really hard on, you know, a lawyer on one side or the other, even when you think like, well, wait a second, I know this justice has been super sympathetic to this in other cases, you know. That said, based on the questions, it does seem like the likeliest thing to happen is the middle box, that the individual mandate is found to be unconstitutional, but that all or most of the ACA still stands. Justices ask questions that, or even just kind of stated their sense that, well, you know, the individual mandate has basically been gone since 2017 now. If that were the key part of the whole thing, it would have fallen apart by now, 3 years later, and it hasn't. So maybe the mandate's not as important as we thought it was. I also think conservative justices tend to be conservative in their interpretation too. And so this idea that, you know, when one provision of a complicated law is unconstitutional, I think there's a tendency to think, well, we don't want to go beyond that. That said, the politics and the jurisprudence around the ACA are obviously very complicated. The last thing I'll say on this slide is that we also have to remember, so the Supreme Court's going to rule, and then policymakers can respond. Congress could reinstitute the individual mandate penalty. They could pass other smaller fixes depending on what the Supreme Court does. So it's kind of all eyes on the Supreme Court, but then quickly, once we see how they rule, attention will shift back to Congress and the administration to respond. Next slide, please. The most important thing to remember is the ACA is the law until it isn't anymore. I get nervous. There's been so much news about this. It's obviously the case is really important. The implications are significant, but it's still the law in the meantime. And folks are going through open enrollment right now. And all the plans you're looking at, still have to follow the ACA rules. We don't anticipate a ruling until the spring or as late as next June. So nothing will change until then, at least. I think the last thing I'll mention, and I always love just two last things. The Adorable Care Act was a PR campaign back from 2010 when the ACA was first being implemented. Talking about this stuff is often kind of a downer. So, you're always happy to have a cute animal picture, right? But I think what's most important to remember is that our advocacy, your advocacy to protect access to care and access to insurance will continue. We know that access is not perfect, even with the ACA being law. I think it sets a pretty crucial baseline, but we know there are lots of other issues that people have. And our advocacy on behalf of the community will continue. And I know that yours will on both the state and federal level as well.